Sometimes the biggest, most intense battles start with something as simple as a front lawn. Today, we're diving into a legal case out of Sun City, Arizona, where a disagreement over landscaping between a homeowner and her HOA completely spiraled into a formal administrative hearing. It's a classic neighborhood story, but when you dig in, the details reveal this fascinating clash over rules, authority, and of course, money.
And this right here, this quote is the spark that lit the whole fire. It's taken directly from the official petition filed by the homeowner, Catherine Mullane. Her accusation couldn't be clearer. She's saying the board of management for her condo group spent a whole lot of money on a project that she claims was never properly approved by the community. This one sentence kicked off a major legal battle.
So, let's really unpack what Miss Mullane was arguing in her complaint. What were the specific rules she believed the board had just completely ignored?
Okay, so her case really boils down to these 4 key points. First, she said the Board of Management, or BOM, simply spent way more money than they were allowed to. And she pointed to the original community bylaws, which said that any expense over just $50 needed a community vote. $50! She also argued that a huge change, like redoing the landscaping, needed a 2/3 vote of every single homeowner, not just the people who happened to show up for a meeting. And finally, she just laid it out there. A lot of the residents just plain didn't like the new desert look.
This quote from Ms. Mullane's testimony really gets to the heart of it, doesn't it? It just makes it so clear that this fight wasn't just about boring bylaws and budgets. For her, it was about pride of ownership. It was this feeling that the board was being careless with their shared property, treating it like it was, in her words, rinky-dinky.
But of course, there are always 2 sides to every story. So how did the Thunder Fe Condominium Group respond to all this? Well, their defense paints a very, very different picture of what went down.
The HOA argued this was anything but a sudden, rogue decision. In fact, they laid out a timeline showing that this whole idea was first approved way, way back in 2010. And here's the kicker. In January of 2014, the homeowners at the annual meeting voted unanimously to raise that ancient $50 spending limit to a much more realistic $7,500. So from their point of view, they were just following a plan that had been in the works for years.
And why the big push for desert landscaping in the first place? Well, it came down to money. The HOA showed they were facing a massive 87% rate hike from their water company. I mean, that is a huge financial hit for any community. By making the switch, they projected they'd save about $400 a month. So this wasn't just about how the place looked, it was a serious financial move to protect the community's budget.
So how did the HOA explain that big $13,700 figure from the petition? Simple. They said the project was broken into 2 separate phases. The first phase, which was just ripping out the old grass and sprinklers, cost $6,500. Now that number is important because it was deliberately kept under that newly approved $7,500 spending limit. The second phase, with all the new contouring and rock, happened in the next calendar year, 2015.
So with these 2 completely competing stories, the case went to a formal hearing. This is where an administrative law judge would hear testimony from both sides and look at all the evidence to figure out what really happened.
To help the homeowner's case, another resident, Jacques Ledbetter, testified, and her experience really highlights a potential communication breakdown. She described just waking up one morning to find her lawn half torn up, a mix of rock and grass, and she had no idea what was happening. So even if the HOA did send out notices, her testimony suggests that maybe not everyone was in the loop. And this slide right here, this really gets to the absolute core of the legal fight. It was a battle over interpretation. The petitioner was arguing that the rules required a vote of all unit owners, period. The HOA pointed to language saying it was a vote of owners present at a meeting. The petitioner stuck to that old $50 limit, while the HOA had the meeting minutes showing a unanimous vote to raise it to $7,500. It all was going to come down to which version of the rules the judge found more believable.
So after hearing all the testimony, reviewing all the bylaws, the meeting minutes, the financial records, the whole shebang, the judge had to make a final ruling based on all that evidence.
All right, this is the moment of truth. Who did the judge side with? Was it the homeowner who felt the board had totally overstepped its authority? Or was it the HOA who claimed they were just following a long-approved plan to save the entire community a bunch of money? Now, before we get to the verdict, it is super important to understand the legal standard the judge was using here. This isn't a criminal case, so it's not beyond a reasonable doubt.
The standard here is called preponderance of the evidence. All that means is the judge has to be convinced that one side's story is more probably true than not. It just has to be a little more likely.
And the final decision was a clear-cut win for the Homeowners Association. The judge ordered that Catherine Mullane's petition be dismissed.
So why did the judge go that way? Well, the decision really came down to proof. The HOA successfully showed that it was more probably true than not that they had followed the rules. They had the meeting minutes to prove that the vote to raise the spending limit was totally valid. They have the invoices to show that the first phase of the project came in under that new limit. And at the end of the day, the judge decided that the homeowner just didn't have the evidence to prove her case.
This whole case, which all started because of a simple landscaping project, is actually a really powerful reminder for all of us. It all came down to the fine print in the bylaws and what was written down in the minutes of those meetings. And it leaves us with a really important question to think about. Whether you live in a condo, a planned community, or even just a small town, how well do you really know the rules that govern your own home?